One wrong word during a traffic stop, and you could be facing arrest, even if you've done nothing illegal. Last month, 3 gun owners were detained and searched because they fell for these exact police tricks. Today, I'm breaking down 5 dangerous tactics cops use during traffic stops that could get you arrested or sued. By the end of this video, you'll know exactly how to protect your rights and drive away safely every single time. Here's what makes this urgent. Under Pennsylvania versus Mimms, cops can legally force you out of your car and search you based on almost any reason. That's happening right now to law-abiding gun owners who think being polite means answering every question. But those innocent answers? They're being used as legal ammunition against you in court. Point number 1. The small talk trap that gets you searched. When that officer walks up to your window asking, "Where you headed tonight?" or "What have you been up to?" That's not friendly conversation. That's the investigation. Police are specifically trained to use these innocent-sounding questions to gather evidence they can use to search your vehicle, detain you, or make an arrest. Here's the legal reality. The moment an officer starts asking questions, you're being investigated. And here's what shocks most gun owners. Cops are not required to read you your Miranda rights during a traffic stop. You heard that right. Those rights you think protect you on the side of the road. They only apply if 2 conditions are met. You must be in custody and actively interrogated. Standing next to your car answering questions doesn't count. The consequence? Let's say the officer asks what you've been doing and you mention having dinner with friends. He asks if you had anything to drink. You admit to 1 beer with your meal. Completely legal, right? Wrong. That single admission gives police probable cause to investigate you for DWI. You'll be detained for field sobriety tests, potentially arrested, and you're looking at thousands in legal fees defending yourself. Even if you win in court, you've already lost your time, money, and peace of mind. Here's your solution. Stop engaging in small talk immediately. You are legally required to provide your driver's license, registration, and proof of insurance. That's it. Hand over those documents. Then exercise your 5th Amendment right. But here's the critical trick within the trick. You can't just stay silent. According to Supreme Court cases Salinas versus Texas and Berghuis versus Thompkins, your silence can actually be used against you in court unless you explicitly invoke your right to remain silent. The correct response: "Officer, I'm exercising my right to remain silent." Then don't say another word. Not, "I don't want to talk." Not, "I'd rather not answer that." Use those exact words to protect yourself legally. But there's another way cops bait you into this trap: through aggressive attitude. Point number 2, the attitude escalation trick. Here's a tactic that catches gun owners off guard. Some officers will deliberately use an aggressive tone or confrontational attitude when they approach your vehicle. This isn't about the officer having a bad day. This is a calculated strategy designed to trigger an emotional response from you. The trap works like this. The officer comes to your window with hostility. He's short, demanding, maybe even slightly disrespectful. Your natural instinct is to mirror that energy. You raise your voice slightly, you show frustration, maybe you make a sarcastic comment. The moment you do that, even if you don't threaten anyone or do anything illegal, that officer now has justification to claim his officer's safety is at risk. Under Pennsylvania versus Mimms, that claim of safety concerns gives police the legal authority to order you out of the vehicle and perform a pat-down search. They don't need to prove you're actually dangerous. They just need to document that your attitude and behavior made them feel unsafe. That's an incredibly low bar, and it's being used against gun owners every single day. The consequence: you're now out of your vehicle, being searched on the side of the road. If you're carrying, even with a valid permit, this situation just became exponentially more complicated. If you react negatively to the search, you could face charges for resisting detention. One gun owner in Texas last year was arrested for assault on a public servant because he pulled his arm back when an officer grabbed him during a pat-down. That's a felony charge that can cost you your gun rights permanently. Your solution: do not take the bait. No matter how unfair or aggressive the officer's attitude seems, you must remain calm and neutral. Keep your tone respectful, your hands visible, and your responses minimal. Do not argue, do not match their energy, and do not show visible frustration. The officer is looking for any justification to escalate. Don't give it to them. Think of this as a test of your self-control where the stakes are your freedom and your Second Amendment rights. This next mistake is even more dangerous because it happens without you saying a single word. Point number 3, using your movements against you. You reach over to grab your insurance from the glove box. You lean toward the center console for your registration. These normal movements during a traffic stop can be twisted into justification for a full vehicle search, or worse. Here's the scenario. The primary officer is at your driver's window while a backup officer positions himself at the passenger side, looking through your windows. If either officer sees you reaching toward the center console, the glove box, or making any sudden movements, they will claim officer safety concerns. You'll be ordered out of the vehicle at gunpoint, forced to the ground, and your car will be searched top to bottom. This isn't hypothetical. This happens constantly to gun owners during routine traffic stops. The legal framework cops use is still Pennsylvania versus Mimms, which gives police remarkably broad authority to act on perceived safety threats. The key word is perceived. They don't have to prove you were actually reaching for a weapon. They just have to claim your movement made them feel unsafe. That's a standard so low it's almost impossible to challenge in court. The consequence: if you're carrying concealed, which is your legal right with a permit, this situation becomes a powder keg. Officers spot your firearm during the search. Now you're explaining your permit while handcuffed on the side of the road. Even though you've broken no laws, you're being treated like a criminal. And if you made any movement they deemed furtive, that gets documented in the police report as suspicious behavior. That report can be used against you if any charges are filed, and it makes you look guilty even when you've done nothing wrong. The financial reality: legal defense for even a simple charge related to a traffic stop search averages $5,000 to $15,000. For felony charges, which can result if police claim you were reaching for a weapon, you're looking at $30,000 or more in legal fees. That's for defending yourself when you were completely innocent. Here's your protection strategy. First, never store your insurance or registration in your center console or glove box. Keep these documents in your sun visor or driver's side door pocket where you can access them without reaching across your body. Second, keep both hands on the steering wheel at the 10 and 2 positions the entire time officers are at your window. Do not move your hands until instructed. Third, if you must reach for documents, announce exactly what you're doing before you do it. Officer, my registration is in the glove box. I'm going to reach over slowly to get it now. Then move deliberately and slowly. Make every movement visible and predictable. Never make sudden movements. Never change your demeanor quickly, and never give officers any reason to claim they felt threatened by your actions. Your goal is to be completely boring and predictable from a safety standpoint. But even if you control your words and movements perfectly, cops have another trick that targets your legal rights directly. There's a legal maxim that applies here: consent cures all. What this means is that once you give consent, police can do almost anything during that search, and you have no recourse. They can damage your vehicle. They can hold you there indefinitely. They can seize anything they find, even things you didn't know were in your car. Maybe a previous owner left something illegal in a hidden compartment. Maybe a passenger dropped something under the seat weeks ago. Doesn't matter. You consented, so anything they find can be used to build a case against you. The stakes for gun owners: let's say you consent to the search, and police find an old magazine with a capacity that's illegal in your state, or ammunition that violates a local ordinance you weren't aware of. You're now facing criminal charges, potential felony prosecution, and the loss of your right to own firearms. All because you thought being cooperative would help you. Here's the financial devastation: a firearms-related charge from a vehicle search can cost you $20,000 to $50,000 in legal fees to defend. If you lose, you're looking at fines up to $10,000, potential jail time of 1 to 5 years depending on the violation, and permanent loss of your Second Amendment rights. Your career could be destroyed. Your ability to protect your family is gone, all from saying yes to a search. Your solution is simple but requires confidence. Never, ever consent to a search. The exact words you should use: "Officer, I do not consent to any searches." If they ask again, and they will, repeat the same phrase. Do not elaborate, do not explain, do not justify. Just clearly and repeatedly deny consent. Now here's what happens next. Police may order you out of the vehicle anyway under officer safety. That's legal under Mimms. But by refusing consent, you've now put the burden back on them to meet what's called the motor vehicle exception to the search warrant requirement. This is a legal standard created in Carroll versus United States that requires police to meet 4 specific conditions before they can search your vehicle without consent or a warrant. Those 4 requirements: 1. They must have probable cause, actual evidence of criminal activity, not just suspicion. 2. Your vehicle cannot be on the curtilage of your property, meaning your driveway, carport, or immediate home area. 3. The vehicle must appear to be operational and mobile. 4. They can only search areas where the item they claim to be looking for could reasonably be located. This standard is much harder for police to meet than getting your consent. That's why they pressure you so hard to just say yes. By refusing consent, you're protecting your constitutional rights and making it much more difficult for police to conduct an illegal search. If they search anyway and find something, your attorney can challenge the legality of that search in court and potentially get any evidence thrown out. But police have one more major trick they'll use when you refuse consent, and it involves a four-legged threat. Point number 5, the drug dog threat and delay tactic. Fine, if you won't consent, I'm calling in a K9 unit. We'll see what the dog finds. You can wait here, might be a couple hours. This threat is designed to intimidate you into changing your mind and consenting to the search. Here's what you need to know. This threat is often a complete bluff, and even when it's not, you have significant legal protections against it. The Supreme Court case Rodriguez versus United States established a critical rule. Police cannot extend a traffic stop to conduct a dog sniff unless they already have reasonable suspicion of a crime. Let me repeat that. They need reasonable suspicion before they can make you wait for a drug dog. If they don't have that suspicion, holding you for a K9 unit is an unconstitutional seizure of your person. Here's the timeline that protects you. If an officer has already written your citation or ticket for the traffic violation, their legal authority to detain you ends the moment they hand you that ticket. They cannot make you stay longer just to wait for a dog. If they do, and the K9 search takes hours, that's an unreasonable detention, and any evidence found could be suppressed in court as an illegal search. But here's where gun owners make a critical mistake. They think, I don't have anything illegal, so I'll just let them bring the dog. This is dangerous thinking. Drug dogs are notoriously unreliable. According to the Fourth Circuit Court of Appeals, drug dog accuracy can be as low as 43%, meaning these dogs are wrong more often than they're right. Even worse, in Florida versus Harris, the Supreme Court ruled that even if a drug dog is not trained on the specific substance it alerts to, police can still use that alert as probable cause to search your vehicle. So a dog could alert on your car for a substance it was never trained to detect, and that's still considered legally valid probable cause for a full search. The practical consequence: a drug dog scratches your paint, alerts on your vehicle correctly or incorrectly, and now police have the probable cause they needed to search without your consent. You're stuck on the roadside while they tear apart your car. If they find anything, a forgotten shell casing, an old pocket knife that violates a local ordinance, anything, you're facing charges. And it all started because you thought letting them bring the dog would get you home faster. Your defense strategy: first, record the entire encounter. Your phone's video recording creates a time-stamped record of everything said and done. This protects you if police later claim different facts. Second, clearly state you do not consent to any searches, including a dog sniff. Third, repeatedly ask, am I free to leave? This is crucial. Each time they say no, you're establishing that you're being detained without reasonable suspicion. This builds your case that your constitutional rights were violated. Finally, remain calm regardless of threats or pressure. Police may try to intimidate you with talk of drug dogs, long delays, or how much easier things would be if you just consented. Stand firm. Your rights don't disappear because an officer makes threats or tries to pressure you. But what happens if you do everything right and police arrest you anyway? This is where most gun owners make their worst mistake. Let's recap the 5 tricks cops use during traffic stops that could cost you your freedom. Point number 1, small talk trap. Innocent questions used to gather evidence for searches and arrests. Point number 2, attitude escalation. Aggressive behavior designed to trigger your response and justify detention. Point number 3, movement manipulation. Normal reaching twisted into officer safety concerns and vehicle searches. Point number 4, consent pressure. Psychological tactics to get you to waive your Fourth Amendment rights. Point number 5, drug dog threats. Intimidation using K9 units to force consent or create illegal delays. Any one of these tricks could cost you thousands in legal fees, years in prison, or your right to own guns forever. If you're arrested despite following these steps, do not run. Do not resist. These are the worst possible choices. Resisting arrest or fleeing gives police an easy charge that will stick, even if the original stop was questionable. Stay calm. Remain silent except to invoke your rights, and wait for your attorney. The battle is won in court, not on the roadside. Don't let confusion about your rights during traffic stops put you at risk. Subscribe to Guns Law Guide so you never miss an update that could keep you legal and protected. I break down complex gun laws and your constitutional rights every week so you can carry with confidence and defend yourself legally. Next video, I'm covering how to stop cops from checking your gun during traffic stops. The mistakes that get gun owners arrested even with valid permits. You won't want to miss it.